What do you think? 34 counts of the same charge.
Well, so ask me if I know any more now than I knew when we were on radio together, which was before the arraignment. It's a simple answer. No. I mean, the indictment is so bare bones. It's not only 34 paragraphs, they're all identical, except for the date is changed and the numbering is changed because they're each numbered. But basically, what Alvin Bragg has done is to follow the New York State procedure, which is to tell the defendant as little as possible. But the defendant, Donald Trump, knows that for each check that he wrote to Michael Cohen or wire transfer he gave to Michael Cohen to reimburse Cohen for the money Cohen laid out to these two ladies, not one, each one of those, because they came from corporate funds and were used to benefit a campaign, violated both federal law and New York State election law. It may also have violated IRS regulations because the money was a personal expense and it was billed as a corporate expense. Big picture, if his name were Donald Wilkow or Donald Napolitano instead of Donald Trump, this case would not have been filed. There may have been a fine, there may have been an adjustment on taxes, an adjustment on forms filed, but it would not be a major criminal prosecution. But because he is the former president and maybe the future president, the DA, as is his discretion, has gone after him aggressively.
Let me play a clip of Alvin Bragg for you and get your reaction.
I've been doing this for 24 years and am no stranger to rigorous, complex investigations. I bring cases when they're ready. Having now conducted a rigorous, thorough investigation, the case was ready to be brought, and it was brought.
Your reaction?
Well, the question was, why did you bring it now? Was it intended to interfere with the election campaign? Obviously, he's not going to say it was. He's going to say we brought it when we had the evidence and when the jury was ready to vote. The interesting question is, when will this be resolved? There's an event in August, and there's another event in December. The one in December is supposedly the last event before the trial scheduled for January. Trump would like to delay. If I were Trump, I'd want it over with. If I were Trump, I would get on that witness stand and say, I did everything I've been accused of. It was to save my marriage. I was worried about Melania, not Hillary. Because if this is a personal expense, no crime, no harm.
If Alvin Bragg is going to maintain that it's not political nature, which we've been seeing, all through the press and MSNBC and CNN, if I could ask Alvin Bragg one question, I would ask this: have you ever, and would you ever go to this length to resurrect, as you said, Donald Wilkow or whoever, Donald Napolitano? Would you go to this length to resurrect a case like this and bring it to a court for anyone else? Because you and I talked about this earlier. We're talking about something that was examined by the Mueller team. They did nothing with it. The FEC got wind of it. They did nothing with it. U.S. attorneys, they did nothing with it. State attorneys, they did nothing with it. The previous Manhattan DA, he did nothing with it. So if it's not political in nature, tell us that you've either done this before, or if you see anything like this again, you'll go to the exact same lengths while you're knocking felonies down to misdemeanors, and violent felonies in the city are at a 15-year high.
Well, that's a great summary of the state of affairs where we find ourselves right now, Andrew. I know you have been self-effacing about yourself that you're not a lawyer, and I busted you on air. Where did you go to law school? But you have just made. I'm gonna send this tape to Tacopina, Trump's lawyer. You have just made a brilliant and gifted summation or opening argument, whichever the case may be, to the jury. The government has a lot of holes here. Now, there is meat on the bones, which we haven't seen, which will be revealed slowly. The first thing Joe Tacopina, Trump's chief lawyer, will do is to move to dismiss on the grounds that it doesn't adequately allege a crime. That forces the DA to come forward with all the detail, all the documents that he showed to the grand jury, whatever Michael Cohen told the DA, whatever Michael Cohen told the grand jury, whatever documents Michael Cohen brought in, that he brought to the grand jury. That's the way you find out about the case. Tacopina has two goals. One, get as much information out of the government as possible. Two, force the judge to make a lot of rulings, because he's human and he's bound to make mistakes. And when a judge makes a mistake on the law, that's the basis for appeal if there is a conviction. If you don't force the judge to make a lot of rulings, you're not going to get a lot of mistakes. If you don't file a lot of motions against the state, you're not going to get a lot of information out of them. You want information out of the state, and you want to force the judge to rule on top of rule on top of rule.
Is it normal for essentially a county judge to take on, a county district attorney to take this on, and not a state prosecutor?
Well, the short answer to that is, in New York, yes. In other states, no. There is no state prosecutor in New York. The Attorney General of the state of New York, Andrew Cuomo, has bemoaned this into my ear 100 times, does not have the authority to seek indictments. Letitia James, the current Attorney General, cannot indict. There are no state prosecutors in New York. There are state investigators. But if she sees a crime, if Andrew Cuomo, when he was the Attorney General, saw a crime, he had to bring it to the county DA. So all prosecutions in the state of New York are done in behalf of the people of the state of New York. Case is called People v. Trump, but by the county district attorney. In New Jersey, in the federal system, it's quite different.
Did any state investigators get involved in this?
It's a good question. We don't know that yet. Another question I would ask is, did any feds get involved in this? Alvin Bragg is a former federal prosecutor in the same office that prosecuted Michael Cohen, but decided not to prosecute Donald Trump for the campaign violation. But Bragg knows how to enlist the assistance of the feds if he needs them. Joe Tacopina needs to find out if that's the case, and if so, who they were, and if so, what they brought to the table.
When Cy Vance said that he was told to stand down by the U.S. attorney, why would a U.S. attorney tell the Manhattan DA to stand down from a case that he clearly had good evidence on?
I scratched my head when I heard that, and I would ask it differently, Andrew. I would say, why would Cy Vance listen to the Attorney General? I would tell him to go take a hike. They're two independent sovereigns. The feds can't stop a state prosecution. There's a statute and there's case law right on point. I would imagine Bill Barr was trying to save President Trump from having to deal with a state criminal prosecution while he was still in the White House. I don't know what the rule is on a state prosecution against a sitting president. The rule in the federal system is they have three opinions. Two say you cannot prosecute. One says you can. But since the Nixon era, the DOJ, no matter who runs it, has held on to the view that you cannot prosecute a sitting president. So perhaps that was the argument that Bill Barr made to Cy Vance, but it's a head scratcher. I know Cy, he really wanted to bring this case. Why he didn't bring it, I don't know, but that's not a good reason not to.
Do you
if
think
I was Cy,
yeah, sorry.
Bill Barr said to me, "Don't bring the case," I would have said, "Have a nice day, Attorney General. It's nice chatting with you. Goodbye."
Or was it possible, just a good piece of advice? Hey, I don't think you have a very strong case here, and you might embarrass yourself.
Could very well have been, because Bill Barr's attorneys are the ones who, when Michael Cohen got out of jail, the feds grilled him as if he were a witness in a federal case against Donald Trump. And they decided he lacked sufficient credibility to testify before a federal grand jury and a federal trial jury should there be an indictment.